I've been practicing law now for 33 years. And in fact, I'm about to enter my 34th year of practice because it was September of 91 when I got sworn in as an attorney. So I've had a lot of things happen along the way and a lot of stories. I've told a lot of stories just to other people. And occasionally I tell stories here on my channel. And I have a story. I don't think I've told this story before, and if I have, I apologize. But I guarantee you that right now someone is saying, yes, Steve, you've already told this story. And other people are saying, nope, never heard it. I suppose it's possible. I could have done it, and some people didn't hear it. But anyway, this is a story about how some attorneys think. Not me, but other attorneys. Or at least how I think about other people who think funny things when they're attorneys. But I had a case a while back, and it's not important what the subject matter of the lawsuit was, but I had a client who hired someone to do some work. And they screwed the work up in such a way that it looked like they had damaged my client's home. And the person doing the work said, well, I may have damaged your home, but I still did some work. I deserve to get paid. My client said, I'm not going to pay you if you damaged my house. And so the person doing the work filed a lawsuit against my client. My client tells me this story, shows me the lawsuit, and I said, okay, so we filed a counterclaim. So if you sue us, we get to counterclaim you for free. Thank you very much. And so we go to court, and it's in a district court, which is the lower jurisdiction courts in Michigan are the district courts. And we go into a district court, and they're claiming that they're owed, I think it's a couple $1,000s. And our counterclaim said basically we easily have that in damages, so it should be a wash. Right? So we go into court, and we're in front of a judge, and the judge goes, a settlement conference. He goes, guys, I'm not even going to get involved in this one. You go in a conference room, and you settle it. And the implication was if we didn't settle it, the judge would be upset. Might give us a trial date, but it's not going to be fun. And this is a judge you didn't want to upset. Let's just put it that way. I had a couple situations with this judge over the years. And so we do the thing where there's 3 conference rooms, and my client goes in one, his client goes in another, and the attorneys meet in the middle. And we were discussing this. And the other attorney, I'm not making this up, was actually the father of the client. So in other words, the guy who filed the lawsuit against my client was the son of this attorney. And because of that, the attorney had kind of this twisted sense of justice as to what should happen in this case. And he kind of like, it's kind of like a personal affront to my boy that you have defended this lawsuit by filing a counterclaim when you ought to just pay him. And I've got these pictures of what he did to the house. I'm like, look at the pictures. I don't need to see that. My son does good work. And the guy kept insisting. And it was clearly a situation where he couldn't see reason because it was his son. And by the way, I've had situations before where people who are attorneys emotionally invested in a case, including one in which this would be a whole story altogether differently, but I actually had a case where my client, and I don't do a lot of divorce work, but in one of the rare divorces I did handle, my client was married to an attorney who represented himself in the divorce. And at one point I said, have you considered hiring an attorney? And he blew up on me. But he would have been better off, trust me. But back to this case. So it's a settlement conference. So at one point or another, I said, you know something, dude, this is stupid. You know as well as I do that your client did some damage to the house. And my client's got a right to bitch about that. And the amount of money that you're claiming is so de minimis compared to the claim my client could make. I mean, if we go to court and have a trial, that your client's facing some massive exposure here. So why don't we just walk away from this? You drop your suit, we'll drop our counterclaim, and we both move on with our lives. The guy goes, no, we're not going to do that. And we went back and forth for quite some time. And then finally, the guy comes back and he goes, I think I have a solution here. I go, what's that? And he goes, your client will agree to pay $20. $20. Now, I've settled cases for small amounts of money before. Not $20. But interestingly, because he is the father of the client, he can't claim, oh, my son owes me thousands of dollars in attorney fees, because everyone knows he's doing this as a favor to his kid. So he can't use that lever. Because I've gone in before where someone's offered me $100. We'll pay you and your client $100. Okay, my client's got to pay me. Oh, that's your problem. No, it's not, depending on the statutes we're suing under. So this guy goes, my client wants $20. Now, I know what he was doing. He didn't think I knew what he was doing, but I knew what he was doing. So I went back to my client and I said, hey, they've offered to settle the case where we're both going to drop our lawsuits and you're going to pay $20. My client goes, is he up to something? You're like, what's that all about? $20. $20. I go, oh, he's trying to do something, but it's not going to work. But I think we should go ahead with this. My client goes, okay, is this going to get me out of the lawsuit? I go, yes. Don't have to pay anything other than $20. I go, it's not even going to cost you $20. He goes, okay. So I go back to the guy and I go, we've got a settlement. Let's put it on the record. And so you can settle a lawsuit different ways. One of which is you draft a release and both sides sign it, and then you submit a stipulation to dismiss the case with the court. But the release is what governs the settlement. Okay, so obviously settlement agreement or settlement agreement and release or release and settlement agreement. But the settlement agreement is what releases the claim one party has against another, but we're both suing each other, so we have a mutual settlement and agreement to release. Okay, so that's how we do that. But not here. I said, well, I want to put this on the record. I want to go in there and put this on the record. And so you can go into open court. And by the way, the court rules in Michigan specifically address and say there's two ways you can settle a case. One is settlement release agreement or put on the record. And by putting on the record in open court means you're going to come into the court with a court reporter or video recording equipment. The judge is going to have you put the terms of this agreement on the record. The judge will listen to them, and if it meets the approval of the court will approve almost anything, especially on a low dollar amount. That it's not that big of a deal, but then we don't have to do paperwork. There's not going to be any fighting later. I've actually had cases before where we settled something. Judge goes, do you want to put it on the record? My opponent goes, no, Your Honor, we'll draft documents. We'll do a release. And then the opponent sends in a release with some absurd thing in it. I actually had a case against one of the major automakers in Detroit where we agreed to settle the case, but I said, I'm going to continue my case against the dealership because we were alleging two things, a defective car and fraud. Fraud as the dealer, defective car as the GM. I go, we'll dismiss our claim against GM as long as we can proceed against the dealer. We put that portion of it on the record. Then, when we left, the attorney from the manufacturer, did I accidentally say the name of the manufacturer? I'm trying to remember if I did or not. If I did, I'm going to have to cut it out. But the attorney for the manufacturer sent over a proposed release, and I knew what their releases looked like, and they had added a section that says, plaintiff shall indemnify the manufacturer against any cross claims filed by the dealer. I go, who said that? And she goes, you did. I go, I never said that. She was out in the hallway, you said that. I go, I never said that. I guarantee you, I think she was convinced that I had said it, but I didn't. And I think she was actually thinking of somebody else because she handled a lot of cases. I said, I never said that. There's no way I would tell my clients, yes, we're going to let the manufacturer out. But then we may have to pay for their defense if they get cross-claimed by the dealer. No, never in a million years. And they brought a motion to compel it. And in court, I said, Your Honor, look at the court rule. It's got to be signed in writing or on the record. Show me where it says I agreed to indemnify anybody or my client. Judge looks to the other side and goes, anything in writing? She goes, no, but she actually said my client because there's actually a person representing the dealership there, not an attorney, along with the attorney. And she goes, no, but my client will testify that he said that. I said, Your Honor, show me where the court rule says verbal statements of anybody made off the record can be enforced if attested to by somebody else. Court rule doesn't say that. Judge goes, I'm going to deny the motion, and I'm going to suggest that you either enter the settlement agreement you agreed to, or draft a release, or we'll sit down right now and hammer it out. And they finally said, fine, we'll release the matter without making you indemnify us against cross claims, which, by the way, never materialized, but it could have gotten ugly if they had. So I digress. So we've agreed to settle our case with a payment of $20. Trust me, this is funny. So we go into the court and say, Your Honor, we've got a settlement. We're going to put it on the record. Judge goes, okay, what's the situation? And my opponent starts talking. I'm just standing there. And my opponent starts talking, and he says, Your Honor, defendant, counterplaintiff, will dismiss his claim against my client And my client will dismiss his complaint against him. And the only money that's going to exchange hands is defendant's going to pay plaintiff $20. And the judge goes, is that correct, Mr. Lehto? Yes, it is correct. Parties are standing right here. Plaintiff, is that correct? Yes, it is. Defendant, counter plaintiff, is that correct? Yes, it is. Judge goes, okay, I'm glad you guys reached a resolution. And my opponent says, Your Honor, I will prepare a judgment and submit it to the court for $20. And I said, Your Honor, no, he won't. Dramatic pause. I reached in my pocket and I pulled out a $20 bill. And I said, Your Honor, I'd like to note for the record, I'm holding in my left hand a $20 bill in U.S. currency, which I'm now handing to counsel for plaintiff, counter-defendant, to satisfy the $20 we just settled the case for. There's no judgment to be entered. Simply dismiss the case. Judge goes, you are correct. And the other attorney turned purple. I'm not sure if purple, dark red. I could have sworn that you could see steam coming out of his ears. I'm not sure if it was counter-rotating or rotating in sync. Because here's what he was trying to do. He was ticked off for whatever reason. He honestly thought that Sonny Boy hadn't done anything wrong, despite the fact he damaged my client's house. Water under the bridge. He was so offended that we went this far with the case that he was hoping that he could enter a judgment against my client and that it would screw up my client's credit score. Now, I don't know if a $20 judgment is going to cause much harm to someone's credit score. But having a judgment against you is something you want to avoid. So if you're ever given the opportunity of paying $20 you legitimately owe to somebody, or having a judgment entered against you for $20, opt for the payment in cash, which is what I did. And we went out in the hallway. My client's laughing. He goes, oh my God, Steve. Because I had the $20 in my pocket. I'd already pulled it up and put it in my pocket so I could just hand it over. And he goes, Steve, he reaches his pocket, pulls out his wallet. He goes, here, let me, I go, no. I go, dude, I don't want your money. I go, it was worth it to me to pay $20 to watch that guy's face. And even the judge was smiling because he saw what I did too. I mean, I've practicing law for 33 years now. I have never seen an attorney hand cash to the other side and go, there you go. We're satisfied. You're satisfied. Legally. Never seen it. So it's funny because later on, the guy was forced to send me the stipulation to dismiss, which I did sign and send back to him, got filed with the court, but no release, no judgment, no nothing. And all there was a court record of me speaking, because this was, I don't think it was videotaped, I think it was simply transcribed, of me saying I'm holding in my left hand a $20 bill in U.S. currency, which I'm now handing to opposing counsel, which will satisfy the claim. Therefore, there's no need to enter a judgment. The judge says, you are correct, sir. So there you go. That's my story involving a $20 bill. I hope I haven't told it before, but it's absolutely true. I guarantee it. Questions or comments, put them below. Others. I'll talk to you later. Bye-bye.